Yeah, my lord, I have a rejoinder.
And you are speaking for yourself and also for the petitioner in number 3? Petitioner number 3?
Yes. Yes, for Eunice Nganga.
Yes. Please proceed.
Yeah, thank you, my lord. I will start from where council has left, and it is being suggested that the outcome of the process done by the panel, allow me to call the panel of experts panel, just for ease of moving forward. That the outcome that they will give, or the product of all this work, will be to make recommendations for legislation. Basically, in terms of policy, that is what they are supposed to make. My lord, I will urge you to look at Article 59, which we discussed yesterday. And
you want me to look
at that
page 29? Article 59. Article 59.
Yes, of the Constitution. Yes, of the Constitution.
Yes.
And find that that is exactly what the Kenya National Human Rights Commission is mandated to do. So it is just duplication. I wish to emphasize that the question that is before the court is not whether victims of offenses or human rights violations do not deserve compensation. We demonstrated the various channels that are there for compensation. The only question that is before the court is this panel one of the lawful processes of compensation or redress. And for the petitioners, the position is that it is not one of those avenues. We submitted that there is no legal basis, and it was confirmed that there is no law that is cited in the Kenya Gazette or the proclamation by His Excellency the President. My understanding of these proceedings, my lord, Mr. Kiongo, for the Attorney General, he can correct me if I'm wrong, represents the panel itself, the Attorney General, the Inspector General of Police, I'm not sure whether he represents the DPP and IPOA. But for the panel, Attorney General and the Inspector General of Police, I would have expected the Chief Legal Advisor to the government to come and tell you, my lord, that this gazette does not refer to any law, but this is the law. Basically, he never tried even to suggest which law under which this panel is constituted. And that is one of the primary questions that are before the court. What we've been told, and this came from Ms. Oganga, is that it comes from international law. Which international law? No law has been cited, and international law cannot be the basis of forming this kind of a panel that is way above the constitutional commissions and independent offices. Yesterday, we demonstrated the way this panel is elevated beyond the IG of police, even the judiciary, because it's performing judicial functions, even above Kenya National Human Rights Commission. I mean, it is a body that is reporting directly to the President of the Republic of Kenya. And this you find in the Gazette itself, where it says, the panel shall prepare and submit to the President periodic progress reports and a final report. That is mandate number F. So they authenticate data from Kenya National Human Rights Commission, IG of Police, IPOA, Ministry of Health, the civil society, and this one I'm reading straight from mandate number C. They pick information from all these, authenticate it, and take it to the President. So it is operating above all these institutions. So which law allows the President to create another layer between him and independent constitutional offices to monitor and authenticate the work that they are doing? My Lord, we would have been told that by the chief legal advisor to the government, but none, that did not happen. And it's because there was nothing to say about that anyway. We've been told that the panel is not compensating anyone. I mean, the outcome of this panel is not compensation. It is recommendation. So for what purpose is it? If Kenya National Human Rights Commission can recommend, that one is taken care of. The IG of police investigates offenses, recommends to the DPP for prosecution, that one is taken care of. IPOA investigates security agencies or personnel in those agencies and recommends prosecution and even compensation. Ms. Nganga demonstrated yesterday under the IPOA Act and the Constitution, IPOA can recommend compensation. So what is this panel coming to do if all those institutions are taking care of those concerns? It is a very unnecessary institution. We've been told, and this was said by Commissioner Omwanza. It was also repeated today by Ms. Oganga. I also heard the Council for the 22nd Interested Party suggesting this, and also LSK, that this panel is necessary, or this kind of mechanism is necessary, when national laws are inadequate and clear, or they are not easy to implement. My Lord, Article 23 and 22 of the Constitution have got no lack of clarity. They have no difficulty in implementing, and that is why we are before you today. We've invoked those articles of the Constitution, and the remedy is right there. Therefore, we don't have any lack of clarity, inadequacy, or any challenge in implementing Article 23, and it has compensation embedded in it. There has been this suggestion that keeps on arising, and this is about inadequacy, that these processes take time. The court, the judicial process will take time and all that. And then the victims cannot wait. That is a very strange argument, my Lord. The petition that is before you today was filed on 17th of September 2025. In fact, there are 3 petitions. Lord, you have given us a judgment date of 28th November 2025. The whole lifespan of this petition will be 72 days. And it will be start to end. So if a victim were to seek Article 23 remedy before you from 17th of September, the determination will be on 28th November 2025. Is it a lengthy process? It isn't. Is it a simple process? Extremely. Is it straightforward? I can't even overemphasize. My Lord, the panel that is being constituted under this Gazette notice has a lifespan of 120 days. 1, 2, 3, 4. 120 days. And it will not give an outcome of compensation. It recommends now go to court and do a process of compensation. Or let us go to Parliament, legislate a law on how you can be compensated. Or let us tell the DPP to charge somebody with an offense. Then compensation will come later. Lord, this panel is not in any way being facilitative.
Please come back on the last statement. I had a problem with my net. You said that the panel would take 120 days to recommend for compensation, which will be taken through the court or to Parliament to make a law. Please start from there.
Yeah, thank you, my Lord. So that it will say, go to Parliament, let us make a law on how you'll be compensated. Or make for someone to be charged in court. Then the whole criminal justice system will go, and then that is when there can be reparations under the Victim Protection Act again. So this panel is not in any way facilitating or shortening the period within which a victim would get any remedy. It is creating an unnecessary obstacle or a procedure like a pre-hearing, or is basically creating a handle that was not there. So my submission is that this panel is misguided, and it is coming to take away the rights under Article 22 and Article 23 and Article 50, Article 9 for victims of offenses. And as I said, my Lord, if we were to accede to this suggestion that we have inadequate, lengthy, and complicated procedures, it would be an indictment on the court that the judiciary is not effective, is a hindrance towards attainment of Article 23 rights and the remedies that are available to victims. So, my Lord, decline that invitation. There being no legal basis under which this panel is founded, what you're then being asked is, we know the panel is not founded in law. But because according to us, the judicial system and other processes are inadequate, let us just do it. Let us just have it. Let's just do it. My Lord, that would be sanctioning an illegality. And my Lord, don't allow that to take place.
So
Yes,
again, I lost you at the point where you are telling me that the court is being asked to accept that the processes are inadequate.
Yes, and they are not friendly or they are not facilitative towards attainment of Article 22 and 23 rights. And for that reason, the same court is being asked, allow us then to go to another process that is extra constitutional to do what you have failed to do. My Lord, graphically, that is what this panel is doing, and kindly decline that invitation.
Sorry, I think I also lost you on the last statement. I think the system is telling you to wind up, Mr. Wathuta.
Yes, kindly decline that invitation because you're being asked to admit that the judiciary is a major hindrance towards attainment of the rights. My Lord, very quickly, Commissioner Omonza yesterday told us that the inadequacy of the victim protection law with regard to providing a remedy to the victims is because the Victim Protection Board has not been operationalized. My Lord, what he did not tell you is that the composition of the board is provided for under Section 31 of the Victim Protection Act. And my Lord, allow me to say this because, it sounds like operationalization is a mega project that need to be undertaken to operationalize this law. These are the people who form the board. And the chairperson appointed by the Cabinet Secretary for Justice. We have a Cabinet Secretary for Justice. He should just appoint the chairperson. Then, Director of the Witness Protection Agency. We have the Witness Protection Agency and it has a director. It has the Principal Secretary, Ministry for the time being responsible for matters of justice. We have the Principal Secretary. Principal Secretary for Correctional Services. These are the appointing authorities. Actually, these are the members of the board. The PS, Ministry dealing with Children Affairs, Director of Public Prosecutions, IG of Police, one person nominated by the National Gender Equality Commission, and two representatives from civil society dealing with matters of children, women, and victims protection.
So my network keeps breaking. You have told me that there is no problem getting the board constituted because its membership is set out in the Act.
Yes, and those people are in office. It's just telling them, you people meet in the boardroom of Victim Protection Board. So it would have been easier to write a memo to these people and tell them to hold a meeting to deal with matters of compensation instead of creating a whole new panel that is not founded on the law. I mean, Section 30 talks about the members of the fund, of the board of trustees that is to manage the funds. Only 3 people: the secretary to the board and 2 persons appointed by the cabinet secretary, one with knowledge of financial matters, another one with knowledge of victim protection. Just those 3 people. So when that serious submission was made that this board is not operationalized, we are being told a letter has not been written by a PS or another. A PS has not gone to meet with regard to this act. My Lord, that is totally unacceptable, and the board, the operationalization of the board does not need any effort to have it function, even today. Mr. Gaga, at some point, deviated.
Sorry, again, I lost you after the submissions on the board. Are you able to get back on that after you are through with the board?
Yeah. Yes. My submission on the board, my Lord, is that all the members of the board... I
have taken that.
Yes.
That one I have taken. That one I have. Yes.
Very well, very well. So the board can be called to order even today, and it will hold its sittings. I was at a submission by Mr. Ganga about reparations for human rights violations, and she went at great length to talk about it. And my Lord, the panel is for victims of demonstrations, riots, and public protests, and not necessarily victims of human rights violations. For victims of human rights violations, she has the same mandate as the chairperson of the Kenya National Human Rights Commission under Section 41 of the Constitutive Act of that commission. And my Lord, when you look at that Section 41, you will see that what the commission can do has been picked word for word, paragraph A, B, and C, and put in the Kenya Gazette for the panel. So basically, that is a mandate which has been taken away and taken to the panel.
Yes.
I think there was a mention of a TGRC report by Ms. Oganga. My Lord, that was created through an act of parliament. TGRC Act is the one that created that commission.
TGRC was created under an act of parliament,
while the panel does not have any law under which it is anchored.
Yes.
The victim suggested that the VPA, Kenya National Human Rights Commission, have not approached his client for purposes of compensation. There is a procedure that is followed. It is in the VPA Act. It is also in the Kenya National Human Rights Commission Act on how violations and victimhood is investigated and redressed. In conclusion, my Lord, allow the petition, find that the law has sufficient mechanisms to redress any victim of these situations. And as I said, a riot, a demonstration, picketing does not cause a victim. There's usually a perpetrator of that violation, or there's a perpetrator who causes the injury. So let us go for that perpetrator, then that person can be held to account.
I think you should come back on that final proposition. You are saying you are distinguishing the riot from violation of human rights?
Yes, my lord, demonstrations,
yes,
protests, those are matters that are in the Constitution. There is a constitutional right to do that.
Yes.
So the incidences that happen during those occasions, say destruction of property, the loss of life, those do not come from the demonstration as granted by the Constitution. It is acts, criminal even, of people who are either within the demonstration, people who come to counter the demonstration, or criminal elements that infiltrate. So the right thing to do with the agencies that the government has will be to identify the violators and hold them to account instead of condemning exercise of constitutional rights as an exercise that causes victimhood. So let us not use a shortcut. Let us go to the culprits. Then the culprits will be held to account. My lord, I don't know whether I've talked. My team members, Wambogo, Dennis, Micheni, I don't know whether there's something I might have forgotten.
You are speaking for them, so if they have not passed you a note, Mr. Wathuta, they have no right of speaking to me. You are the lead counsel. You have to leave it there, but you have not said what you make of the statement that there is no essence in the limitation of 2017 onwards.
Oh, sorry, my lord. Again, the limitation of the period that is covered by this panel is discriminatory on the face of it. And my lord, Eunice Nganga, when sending me instructions, wrote this. My family, we are victims. Our house was burned in 2007 in Eldoret. And then they got help by people, so they escaped. So she gave me that brief about herself. 2007. Why would we leave out a person like the third petitioner out of this framework or whatever compensation without any explanation? If at all we want to deal with the issue of reparations, we cannot be selective. And that is the bill that is currently in Parliament, sponsored by the woman representative for Uasin Gishu, Gladys Bushare, the reparations bill. So, as I said, let us not use shortcuts. Let us use the legal mechanisms that exist. And if the panel is to make recommendations on legislation, the legislation is already before the Parliament. So when it comes for public participation, that is where the feedback should be given. So when we start doing this, another person will come, create another panel for people of 25th of June 2024. Another one, 25th of June. I mean, that is not sustainable. Therefore, I still maintain the panel as it is discriminatory and therefore unconstitutional. That's all right.
Thank you. I have had you and I have Kotka confirm we have everybody's submissions printed and also on the system. Thank you all very much. We have already set a time for Friday. Is it Friday 28th?
Yes, Your Lordship, on 28th.
Yes, 28th of 11. And did we say a time? I think we log in at about 9:30. If I'm ready with it, we'll give it right away. If not, I'll tell you what other time on the day it shall be. But we shall endeavor to make it happen on that day. Do we have any adoptions on the day?
Most obliged, my lord.
Most obliged, Your Lordship.
Good. Thank you very much. 28th of November, we say at 10 a.m. Thank you.
Most obliged.
Good evening. What time is it now? Thank you.